Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. First, I want to verify this is Tyler Watkins.
Yes, it is, sir.
Mr. Watkins is here today after failing to appear before referee Snyder on February 5th, 2024. Bond is currently set at $7,860. This is the 8th bench warrant. He reports no employment. Last payment made on this account was in May of 2020. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on March 27th, 2024 at 8:45 a.m. before this court.
Okay, thank you. Mr. Watkins, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 27, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Your Honor, I'm not able to post a bond, and reason is I just got out of jail for child support. I just did 280 days. 6 months ago, I got out of jail. I was homeless for 3 months. I finally got into a place. I have 2 little girls. I've been going to custody court for them. I got them 6 days a week. Okay, I didn't have them yesterday. I'm supposed to get them today. I'm working side jobs and doing what I can. My mom's helping me as much as she can. I'm never out long enough to get on my feet.
Okay.
I have no license. You know, I'm doing my best. I have to pay rent by myself. I take care of the kids by myself. I have to do everything by myself. I can't get it. I can't even get all the way up off my knees.
Okay. Well, what the court's going to do, the court does note it is your 8th bench warrant, so I'm taking that in consideration, as well as the fact you have extreme arrearage in this matter, having not paid now in almost 4 years.
Your Honor, I was in prison and they didn't stop the payments. They've never lowered my payments since the day I started child support. I've asked multiple times.
You have a right to, whenever you're incarcerated, you have a right to file a petition, get your support obligation suspended. And
I did file it when I was in prison and they never suspended it. I was in prison in Florida.
Well, that's something we'll maybe have to take care of on the 28th.
Yeah. Thank you.
What the court's going to do is I am going to cut you a break in this matter, view of your arrears being so substantial. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
Your Honor, I'm not able to post it and I got to go pick up my 2 daughters.
Okay. Thank you. That's all we need from you today. You're free to go.
In each of these matters, Mr. Smith is here today after failing to appear before this court on September 13th, 2023. For the record, that was a bench warrant hearing. Mr. Smith was previously before the court for a bond review hearing on September 5th of 2023. He was given a $100 bond in each case, which he posted and then failed to appear for the hearing. Bond in each case is currently set at $500. This is the 3rd bench warrant in the 2013 case and the 2nd bench warrant in the 22 case. He reports no employment. Last payment made on these accounts was the $100 bond forfeiture. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on March 27th, 2024 at 8:00 a.m. before this court.
Mr. Smith, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 27, 2024, 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir. Sir, I would just like to talk to you. She's not allowing me to see my kids. She don't let me see my kids. I don't even have their phone number.
Okay, that's as a result. That's a separate action. If you don't get to see your kids, you have a right to file a motion to have the other party held in contempt for not, again, complying with any orders of the court. But that's not what we're addressing today, sir.
I know, and I'm just like, I'm not older in the head right now, man. Like, it's really, really messed me up in the head. Like, me not being able to see my kid.
Okay, sir, the way you're talking, I can't understand a thing you're saying. So
I'm sorry.
Compose yourself and talk such that I can hear you.
Right. Well, I'm sorry. I can't, like, my day-to-day functions ain't normal anymore. I don't know how to explain it to you.
Okay. Well, tell me this: why, back when you were in court on September 5th, I gave you a favorable bench or a favorable bond at that time. And a week later, you didn't show up to court. Why didn't you show up?
Sir, I have not the slightest idea because my head right now is just not there. It's like, I don't know how to explain it to
Okay,
you,
well,
sir.
we're gonna help you, sir, so that you don't miss another court date. The court
I
does
won't
believe in
miss-
view
I
of the
swear to God, I
fact
won't
that you didn't show up the last
I
time
will
when
not miss another
you
court
were
date.
given a favorable bond. The court is going to continue the bonds in the amount of $500 in both cases.
Please, sir, can I get a little bit?
That will
lower,
be the
please?
order of the court, sir. You're free to go. Have a good day.
Sir, please, can I please get
No.
it just a little lower?
No, you can show up on the 27th and we'll talk to you then.
Cause I will show up, I promise you, and everything I love. I will show up, I will go get a job right now.
Well,
I will
you didn't show
I
up
promise.
you didn't show up last time, sir, so I don't have any,
That was my
I don't
first
have
time.
any
That was my
credence
first
in
and
what you're
only,
gonna
though.
say.
That was my first and only time though, sir. Can you please just lower it?
Well,
to
we won't let it
$500,
happen a
please?
second time. Good, thanks.
I
You're free
promise
to
you, I
go,
will.
sir. Mute him and court will note the appearance of Ms. Podolsky on behalf of plaintiff, Ms. Bailey Hobbs on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, spousal support, and exclusive use of the home. Ms. Podolsky.
Thank you, Your Honor. As the court is aware, there is a companion key. That is the personal protection order that plaintiff has against the defendant. Unfortunately, this marriage has a long history of both domestic violence and emotional abuse by defendant perpetrated on the plaintiff. The most recent occurring on January 31st, 2024, wherein the plaintiff was physically assaulted and was transported to Oak Lawn Hospital. And that is what necessitated the ultimate filing of divorce in this PPO. The parties have one minor child and one child who recently became an adult. The minor child was present during this most recent assault, and both children have been present throughout the numerous emotional screaming and shouting and berating, the swearing, the horrific name calling, the abuse. They've been present throughout the marriage. We have both video and audio recordings of defendant when he loses control like this. My client has been a stay-at-home parent throughout the marriage. She is currently working with attorney Jim Hodsma to obtain Social Security disability. She is doing this due to full spinal stenosis and sciatica, as well as other health complications. Because of this, she has not been able to work and will require the support of the defendant in the form of spousal support and child support. With the PPO in place, my client has been residing in the marital home. She and the minor child have no other place to go except for the marital home. But due to her inability to work, she is in need of the financial support of defendant to continue to pay the bills associated with the marital home, including but not limited to the mortgage, taxes, insurance, utilities, and other necessities of life, such as gas, groceries, and things for the minor child. There is a bond between mother and child. They have always lived together since birth. She has been the primary caretaker of the minor child since birth. We have significant concerns because the minor child has been present during these instances where the defendant is committing the domestic violence, the emotional abuse on the plaintiff. We believe that it would be important for the minor child to get into counseling to deal with what she has seen, the trauma that she has seen going on in this household. And we believe it is important now for the plaintiff to be awarded the sole physical and legal custody of the minor child with reasonable parenting time for the defendant. We would leave it to the court's discretion whether that should be supervised at this time in light of the abuse and the current PPO. But we also believe then support consistent with the Michigan Child Support Formula should be awarded as well.
Okay.
Thank you, Your Honor. There are quite a few issues.
Hold on, Ms. Hobbs.
All right.
Ms. Podolsky, I'm looking at your petition and all you've stated for any income for the defendant is defendant has been employed full-time during the entirety of the marriage, owns and profits from rental property, and does construction for various businesses under the table. Court has no idea what his income is to be able to determine whether spousal support or anything else would be appropriate. How am I to guess at that?
Well, Your Honor, that is something that my client has had to do throughout the marriage as well. He has been self-employed. They have one rental that earns $750 per month. He works in construction. He is not employed by a business that we would be able to subpoena information from. He is self-employed. We believe it would be necessary to impute income because we're not able to obtain an actual pay stub for him. We believe in this trade locally, he could earn $20 to $30 an hour in that job as a self-employed construction worker.
Okay. Ms. Bailey Hobbs, you can go ahead now.
Thank you, Your Honor. So there are clearly quite a few issues that need to be addressed in this case. First, plaintiff filed a petition for personal protection order on the same date that she signed her complaint for divorce. That doesn't seem like a coincidence. In fact, her petition for personal protection order was filed on February 16th, 2024. She made contact with the Calhoun County Sheriff's Office on February 15th, the day before she signed her complaint for divorce and filed the petition for personal protection order. And she asked about serving a PPO and the eviction process. She's made false allegations that my client severely physically assaulted her in order to obtain that personal protection order and gain exclusive use of the home without going through the proper channels with this court. Therefore, she's gained an advantage in this divorce action. She has been in possession of the home for almost a month. My client has been unable to work since he was served with a PPO and escorted off of his own property. He's self-employed as a general contractor. His business is located on the property of the marital residence. He cannot work if he does not have access to his shop. That's where all of his tools are. Say the court granted plaintiff exclusive use of the home and then said, defendant, you can put all your tools in your truck. Well, that's not an efficient way to work. He's a general contractor. He would have to unload all of his tools to find the tool that he needed to do his job and then reload all of them back. He has asked, he's asked his daughter who was at the property to allow him to get some of his clothes. He has nothing. She's not allowed to give him any clothes. She's not been allowing him to have any of his tools. And yet she claims that she's desperately dependent upon his income. I just don't see the point in being that desperate to have him pay everything for her, but then refusing to let him make his income. She states that she has no money, but she spent over $400 to change the locks on the property. And she put over $800 in cameras up. She's using the personal protection order to launch an assault against my client with the goal of having him incarcerated. This will be covered more in our motion to terminate, which is later today. But the court does need to know what we're dealing with. It was brought to my attention very early this morning by a trooper with the Michigan State Police that plaintiff filed a report indicating Mr. Osborne broke into the home and stole firearms. She filed this report on the 14th, which was last Thursday. And the Michigan State Police are investigating that report as a false police report having been made. Should this court want to set this for an evidentiary hearing, we will call the trooper that I spoke with this morning and give that information to the court as well. Plaintiff is requesting primary physical and sole legal custody on a temporary basis. That is absolutely not in the best interest of the minor child. The marriage has been tumultuous at times. However, plaintiff is mischaracterizing all of the recent facts in this case, and she's done everything she can to set it up to where it looks like it's in her favor. The minor child is in the home with her mother, witnessing and being present for all of the false allegations that plaintiff is currently making, all of the police that are coming to the home and questioning everybody. The child is not allowed to see her father. Plaintiff also moved her father into the home. And there are multiple men coming and going in and out of the home. The child is scared. She wants to be with her father. To address plaintiff's allegation that the minor child was at the home as far as the incident that occurred on January 30th, or at least the incident that plaintiff mother is saying occurred so that she could gain her advantage in this case. Both children told the police officers that they didn't see anything. In fact, they tried to warn their dad that mom was on the way. She was on a rampage.
Hey, Ms. Bailey Hobbs, I'm not addressing the PPO now. Please move on or we're never going to get done.
I understand, Your Honor. I'm just saying that
I'm just saying move on.
Okay. Well, the issue is that Ms. Podolsky is indicating that the children were home when that happened, and that should be a reason that this court should not allow defendant father to have parenting time, or if the court does, that the court should make that supervised. It is our position, based on the facts that are in front of this court today, that is not necessary. I have nothing further, Your Honor.
Anything? Okay. Well, in this particular matter, the court does note that, as stated by Ms. Bailey Hobbs, that that in fact the child is in the care of the plaintiff. The court notes in paragraph 3 of her answer, she states as well that the child lives with the plaintiff. And paragraph 5 states, defendant father further states that he does not have a residence. As a result, in this matter, the court is going to award to the plaintiff temporary physical and legal custody. Court will allow the defendant to have standard parenting time. We have no income on which to base support, so the court will impute $15 per hour of full-time income. The court will grant to the plaintiff exclusive use of the house during the pendency of this matter. The court will order that the defendant would pay the mortgage, taxes, insurance during the pendency of this matter, or until further order of the court. The court will further order that the defendant shall have a right to get all of his tools and clothing from the home on March 16, 2024 at 12 o'clock noon. Court will order that the plaintiff not be present from 11:30 a.m. until such time as the defendant has taken all of his tools and left. In this matter, that she can have a third party present to supervise, etc., but she shall not be present, so we don't have any issues concerning the PPO, because we're not addressing that until later today. So, Ms. Podolsky, I'll ask that you would prepare that order. I'm not granting any spousal support at this time, as I don't have any additional information concerning income, and the court does note that there was none, and I'm imputing it, but we don't know if there's anything else. We'll address that at the time that we have accurate information.
Your Honor, you said he could come on March 16th. Did you mean March 20th, this Saturday?
March 20th is not this Saturday.
Or not March 20th, I'm sorry. March
Oh,
20th.
yes, yeah. I'm sorry, March 22nd. I was looking at the week behind. So it's March 23rd, I'm sorry. March 23rd, 2024. He can pick up all of his tools and clothing.
Okay, perfect. Thank you.
Okay, thank you.
2024 at 9:13
Thank you, Your Honor.
a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion for in-person trial or to exclude from YouTube. In this matter, I've reviewed your motion, Ms. McNiff, and as Ms. Podolsky points out in her answer, I don't see where you've demonstrated any reason under Michigan Court Rule 2.407 as to why we should not do it by Zoom or, again, by virtual.
Your Honor, I don't think we're as concerned about having it virtual as much as we are about having it on Zoom. My client's not just a doctor, he's also a medical administrator. He's on a medical executive committee for Oaklawn. Later this spring, his image will be on a billboard on I-94 in an advertisement for Oaklawn. The only two issues that we have in this hearing will be spousal support and the education of the children. The spousal support portion will include a lot of very private information about the party's finances. And there are, of course, safety concerns whenever that information is being broadcast to a wide audience. And as this court knows, there are people who do, in fact, capture those YouTube streams and keep them and then use them to put on TikTok or their own YouTube channel. And we're just requesting that this family be permitted some privacy. It would be as simple as the court keeping the door unlocked during the virtual hearing in order to preserve their privacy and not stream on YouTube.
Okay. Ms. Podolsky, anything else?
Just as we stated in our answer, Your Honor, this case is not unlike any other family. We have no opposition to this being virtual or being on YouTube.
Okay, thank you. Well, in this particular case, the court does note that when somebody asks for this, the court does review the criteria under Michigan Court Rule 2.407(c), which I did in this case. I don't see how this case is different than any of the other hundreds of cases that we have, other than the occupation of the plaintiff in this matter. At this point, the court does not feel there is a basis to do that. I will, again, keep this under advisement, and we'll be able to see if there's any changes by the time of the trial on April 2nd and 4th in this particular matter. But at this point, the court is, I'll say the court is not inclined to grant the motion, but I will review it at that particular time as we get closer to the trial date. The court would refer the matter back to mediation should you believe that that might present some chance at resolution. Ms. McNiff, what's your thoughts?
Ms. Podolsky and I have worked closely on this case. We went through a very thorough mediation with Mr. Brundage, and we were able to resolve all of the issues except this one. I don't believe that the issue of the children's education can be resolved at mediation.
Okay.
And that kind of drives the spousal support issue as well.
Okay. Ms. Podolsky, is that kind of accurate in your own belief?
I would agree with Ms. McNiff. I can always speak to my client again if she believes that it could be useful. It is something we could always schedule with the mediator again ahead of trial.
I'll leave that up to the attorneys then to see if they feel that that might be helpful. Otherwise, we will see you on the April 2nd date. And again, should change my mind at that point, we'll address it at that time. Okay, thank you.
2024 at 9:20 a.m.
Court will note the appearance of Ms. Reed on behalf of the plaintiff and Mr. Todd on behalf of defendant. This matter is before the court on the defendant's motion to change the counselor. Obviously, you've had a chance to review that, Ms. Reed. Do you have any problem? I guess apparently Ms. Hunter is not able, or for some reason isn't able to do this. Is that correct?
It's not really my understanding, Judge, as much as it is, Mr. Boitnott lives in Ohio. Miss Hunter, as you know, is here. This whole thing is really based on Mr. Boitnott engaging in his own counseling, and then she can work with that counselor. It's not my understanding that she is refusing to work with him. It's just that her hands are essentially tied, and there is not a lot that she can do until he begins that individual counseling portion of this, which we were in front of Your Honor about a month ago on.
Okay.
So my position is get that individual counseling started. I don't believe Miss Hunter has refused to engage in this. It's just that I don't think she has a lot to work with without that individual counseling component.
Mr. Todd, what's your position?
Your Honor, we do have email Hunter as recently as 2/14 indicating that she's not able to proceed forward with therapy, and she's no longer involved with the case. So she is unwilling to move forward and has stated affirmatively that she's no longer involved.
Okay.
Again,
Well, let's do this. I do note that has been put in the, I think in the answer that Ms. Hunter had recommended individual counseling to occur in Ohio. I take it from all the pleadings, everything else, that hasn't happened. Has that happened, Mr. Todd?
It has been happening. Mr. Boitnott is involved with counseling, has been since early February, and he's been going weekly. And additionally, after hearing this from Mr. Hunter, he did reach out, or from Ms. Hunter, he did reach out to BLND counseling in Kalamazoo, and they are open to do reunification counseling and are willing and able to move forward. And we researched all of that prior to filing the motion because of Ms. Hunter affirmatively stating that she was unable to move forward and is not going to be involved with the case.
Okay. Why don't we do this? Is the court is going to reserve on the motion. If you would, Mr. Todd, get something from Ms. Hunter. If she's saying that in writing that she's not going to be involved in the case, then the court would change the counselor to BLND in this particular matter. If she is able to and willing to continue, that he would continue with the counseling and that they would involve Ms. Hunter with that particular counselor. So kind of a either or, she either is involved or she's not involved, and then we'll proceed that way. And Mr. Todd, you can prepare the order that recites that.
Okay, so in essence, if she affirmatively states she's not involved, then counseling would change, and if she's still involved, then that's fine. It would just continue.
Yes, it would continue. If she says no, I'm not involved and I don't want to be involved, then we'll have again the BLND that will do the reunification counseling.
Okay, all right,
Okay.
absolutely. Thank you.
Okay, thank you.
9:25 a.m.
Have a good
All
day.
right.
We'll note the appearance of
Thank you,
Mr. Todd on behalf of the plaintiff, Ms. Podolsky, on behalf of the defendant in this matter. The matter is before the court on the defendant's motion to set aside default and other relief. Ms. Podolsky.
Thank you, Your Honor. As the court is aware, from our motion, this complaint for divorce was filed on November 13th. However, my client was sent the documents and acknowledged service on November 12th. We confirmed with the clerk's office that all of the dates were in fact correct. So it appears that she was served with an unissued summons. Pursuant to court rules, she must be served with a summons and complaint that have been issued by the clerk's office. So we're asking the court in this matter to set aside the default. She was unrepresented until this time. She was unaware of anything happening in this matter until she received the default. But based on the issue here, we're asking the court to set aside the default to allow her to participate in this divorce. In the event that the court is not willing to set aside the default, we're asking the court to still set this matter for mediation, allow her to participate in the divorce, and direct that the parties exchange the verified financial information forms.
Thank you. Mr. Todd, I think from your answer, you do acknowledge that she was signed or she was served with a summons that had not been issued yet.
No, she was served with a summons that had been issued. And actually what happened is she just technically put the incorrect date on it. If you look at the actual signature page, which we have attached as Exhibit B on our sheet, she acknowledged service on December 11th, 2023. And I attached the entire packet for service.
Did you say December 11th?
Correct. Correct.
I thought
December 11th.
the service was on November 12th.
No. So what happens with the system is it's not day, month, year. It's the other way around within the system. But if you actually look at her electronic signature on the signature page, it is dated December 11th, 2023. It's extremely small and it's under her name. But I sent her the issued summons. That's the only way I would have the summons that had been issued. And so when she dated it 11/12/23, but that is simply because of the system did it the way that they do it in Europe. But if you look at actually under her electronic signature, Allison Leathead, December 11th, 2023, 1856 EST. And I can send all the metadata and all the actual data that would verify that.
Okay. Any response, Ms. Podolsky?
Your Honor, this was the first we learned of this. We had contacted the clerk's office. The clerk's office had it as November 12th as well. That was the basis of the motion. It's clearly what the proof of service says is 11/12/2023. So we would just continue to stand on our motion and ask the judge to set aside the default, or in the alternative, allow my client to participate in the divorce and order the parties to mediation and to exchange the verified financial.
Okay. Well, it does present an issue that the court will have to decide. What I'm going to do is I'm going to reserve on the issue of setting aside default, but I will allow the defendant to be involved in address the disputed items at this point. Why don't we set mediation for April? Ms. Podolsky, who would you like as a mediator?
Mr. Brundage.
Mr. Todd, do you have any problem? Mr.
Yep,
Brundage is fine. Okay. What we'll do is, Ms. Podolsky, you can set an order, say I'm reserving on the issue of the service of the summons and complaint. So we have probably we can address that at a hearing if we need to address that particular issue, because obviously it is confusing. If you take it at face value, it looks like she was served before the summons was issued. If that's the case, the court was going to say that it was improper service, but if they simply had the dates juxtaposed as opposed to being 12/11, but 11/12, then obviously she would have had proper service. So we'll have to address that at a hearing in this matter, but the court will allow the matter to proceed as a contested matter with mediation before Mr. Brundage in April of 2024. Ms. Podolsky, you can prepare that order and submit under 7 days.
Thank you.
Okay, thank you. Free to go. Have a good day.
Thank you.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's notice for entry of order in this particular case. Ms. Reed.
Thank you, Your Honor. We're moving to enter the final order in this case and close the matter. Default was entered on January 17th. We have FOC approval on the orders. The orders that are noticed for entry today match the temporary order in this case, and so we're asking the court to enter the final orders.
Okay. Mr. Japkes, what's your response? Oh, we lost everything.
Huh?
Sir?
No, it's.
Sir.
What?
Who's sir?
Oh, okay. I'm
Hello?
sorry. Ms. Japkes, what's your response?
I still want shared custody, Your Honor.
Okay, well, the issue of this is notice for entry. So if you have an objection to the order, it's not to the substance of it. It's otherwise they had, again, not correctly reflected the court's ruling in that particular order. So if in fact the order is not consistent with the court's prior ruling, then the court would consider that. But the fact that you disagree with the ruling is not a basis for objection.
Yeah.
So do you have anything else, ma'am?
No, Your Honor, I just want what's best for my child.
Okay. Well, the court does not see from what the defendant has stated that there's any objection to the court's, well, obviously there's objection to the court's ruling, but not to the form of the order in this matter. So the court will enter the order as submitted by Ms. Reed. Anything else, Ms. Reed?
No, Your Honor.
Okay. Thank you. That will conclude the matter. You're free to go. Have a good day. Court will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion for modification of parenting time and other relief. Ms. McNiff.
Your Honor, I haven't heard anything from Jessica Hughes on this matter. I would note for the court that this is primarily a Shade v. Wright request for a change in parenting time. There's been an ordinary change in circumstances wherein Mr. Hughes's work schedule has changed. As a result of that change, the parties have agreed on their own in the past year to change the parenting time schedule such that Mr. Hughes has the children every weekend. He would like to have it alternating Fridays and then every Saturday through Tuesday morning. Right now, there's a dispute between the parties in terms of those Fridays. Sometimes Ms. Hughes allows him to take the children on Fridays, other times not. He would like to have a set schedule so that he can have those alternating Fridays. So it's a true 50-50 schedule, which is what they had in the judgment of divorce. So we're asking that the parenting time schedule be changed to reflect both the status quo and that request for the alternating Fridays. In addition, the parties are having difficulties communicating. Ms. Hughes has been excessively calling and texting Mr. Hughes. So we're asking that all communication be through our family wizard so that the court can monitor those communications if necessary and put a damper on those excessive communications if they begin to occur again. And the last issue is the recording of the conversations with the children. Ms. Hughes has been recording them. We don't think that that's appropriate or necessary or legal for that matter, unless she's of course a party to the conversation. So we would ask that the court require that she no longer continue to record those conversations.
Okay. Well, what the court will do in this matter is I have no problem with, again, ordering that the parties would facilitate communication through our family wizard or other appropriate app. And further, the court doesn't take issue with the fact that parties should not be recording the children in any event. If the parties are not involved in the conversation, not a participant, then it's contrary to law in this particular matter, and it would be, again, eavesdropping in that particular issue, and it is a criminal offense. So the court will order that neither of the parties would record the children for any basis in this matter. As it relates to the other, I guess I'll send the matter of the issue of the Friday parenting time to the referee for a hearing that gives the plaintiff or the defendant an opportunity to, again, to address the issue if she has some disputes in this particular matter. And so that's what the court will do. You can address the other issues in the order, and then we will refer the issue of parenting time to the referee.
So just to be really clear, Your Honor, right now, Mr. Hughes is given his parenting time in the current order is from Tuesday to Friday. And the parties have been exercising it so that he has the weekends. May I include that change, or will that also go to the referee?
What I wanted to do, because Friday was a dispute, I wanted to memorialize in the order what there wasn't a dispute about. So
Gotcha.
If there's not a dispute over the other times on the weekends, then that's fine. You can put it in the order, and then we'll only send the issue to the referee. In fact, why don't you in the order just state that, so it's clear when the referee gets it, that it's only the issue of Friday parenting time.
Great, I can do that. Thank you, Your Honor.
Okay, thank you. Have a good day. Elaine, on behalf of the defendant, the plaintiff appearing in pro per. In this matter, the plaintiff has filed a motion to show cause for violation, as she states violation of the order of November 3rd, 2015 and September 25, 2023. The defendant has filed a very thorough answer in this matter, disputing the allegations in the motion to show cause as a result of the dispute, the court is going to have an evidentiary hearing in this matter. The court notes that we have a hearing scheduled for April 9, 2024, and the court would intend to put this matter on at the same date so we can hear all the matters at one time and hopefully avoid some of the expense to the various parties. Anything else, Ms. Tabaka?
No, Your Honor, that sounds good. Thank you.
Okay, Ms. Elaine, anything?
Yes, Your Honor. I would urge this court to consider the underpinning of what is going on here, and that is that Ms. Tabaka will do anything right now to get this court to hold Chris in contempt for anything that he does. She is trying to get a hash mark on her side of the scorecard because she somehow thinks that if she can get this court to hold Chris in contempt, that will somehow mitigate or erase the 3 contempt charges this court has issued against her. And it's critical to note that every time Chris has brought a legitimate show cause, Ms. Tabaka responds with a frivolous one. And I would urge this court to impose a standard here that just filing a motion to show cause does not entitle one to an evidentiary hearing, but that the allegations need to be looked at. And even if her allegations are taken as true, she hasn't pointed to any violation in the court order. If this court entertains show cause motions because one parent didn't notify the other parent that the kid had the sniffles as fast as they could, then everyone on YouTube is going to be flooding this court with meritless and frivolous show cause motions to try to get the other parent in trouble. And I don't think that that is what this court wants. And I don't think that that is the purpose of the judiciary and the judicial proceedings that are available to us. But that at its core is what is going on here. If Ms. Tabaka has a complaint that the kids weren't really sick, then that is something for the custody hearing that we have going on. If she has a complaint that he took them out of school for a trip, then that is a complaint she can lodge during the custody proceeding because there's no court order that prevents him from taking them out of school for a trip. If the complaint is that they weren't sick enough to keep them home, then that again is something that she can allege and assert in the custody hearing. This at its core is a complaint that she is dissatisfied with co-parenting, of course, based on her motivation to just get him in trouble. But be assured there's a lot of dissatisfaction with the co-parenting going around both ways in this case. And if every parent dissatisfied with the other parent's style of co-parenting is going to file a show cause, again, this court is going to endure a tsunami of illegitimate and meritless complaints. And for that reason, I urge the court to see this show cause for what it is, which is meritless, baseless, frivolous, and deny Alexis's opportunity to have any further proceedings on this.
Okay. Well, as the court originally stated, there is a dispute in this particular matter, and it's stated, what's going on and the action's frivolous. I can't make a determination of that until I've heard the basis for the, again, determination. So the court will wrap that into the April 9th hearing, and we can address it at that time. The court can determine whether there's any merit or a frivolous claim at that time. So that will be the finding as it relates to this motion. And you're free to go. Have a good day.
Thank you, Your Honor.
10:07 a.m.
Court will note the appearance of Mr. Reiser on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to show cause for failing to attain dental care as well for adjournment of trial. In this matter, we haven't received a response from Mr. Haley. Mr. Haley, are you disputing the motion?
I am. I do have proof of dental care here for the next appointment.
Okay. Well, I'm just knowing if you're disputing it. They
Yes,
also allege that you had not answered the discovery request. Have you done that?
I have not. The other discovery request is that I admit to form of nothing but I admit all the way down.
Well, those are requests to admit then, and you have to answer those. If you don't answer them within the proper time, they are deemed admitted, and then you can't dispute them. So you
right.
can't just
I
ignore
did not know that. I will get that filled out and sent back then.
You should get that out immediately, or you may have already missed your time frame. I don't know. What I'm going to do in this matter, as he has stated, he's disputing that the court will, in fact, set the matter over for an evidentiary hearing. I note we did have, was that hearing, Mr. Reiser, that was before the referee?
Good morning, Your Honor. Mutu Virpin standing in for Ms. Reiser on behalf of plaintiff. That was before the referee, Your Honor. I believe it was for the 22nd. Discovery is due on the 21st. The hearing before the referee has already been reset. I believe the new date is April 23rd at
Okay.
1:30, I believe.
Okay. Did you get that, Mr. Haley? So it's April 23rd that you have a hearing, but your response to the discovery request is due in a matter of days, so.
Alrighty, if can I email this to Mr. Reiser? He said I could submit anything to him via email. Is that okay?
For email service, the party, to have email service, the other party has to accept and agree to email service. If Mr. Reiser has agreed, then you can submit it by email, but you make sure that you get confirmation that he's willing to accept email service so we don't have that dispute in the future.
Alrighty, and then I do have a question. They gave me a meeting ID on my paperwork here for 669-406-6237, which I felt misled on because that's Judge Heath's for the 7th District Court.
Okay, well,
So
yeah, that's not our number.
and I say this is their form here where you can actually see.
I have no idea. I can't even see the form, so it doesn't do any good to hold it up.
All right, but
Okay.
I do have if you want to list, because it says they want to show proof that there isn't any therapy or anything going on too
Okay,
on this.
well, that'll be part of the hearing that you have on the 23rd.
All right.
Okay.
And then I'll get Mr. Reiser this stuff. If he wants, I can get that in there. And does that include that I have to sign over all medical releases to them too, or?
Again, I'm not getting into the particulars of it because we're setting it for a hearing, but anything else that the discovery requests, then again, you're going to have to respond to that or dispute it, and you haven't done either at this point. So you're going to have to take action on that and get it in before the deadline.
All righty, will do.
Okay. Anything else from the attorney?
Nothing else, Your Honor.
Okay.
Thank you.
Okay. Thank you very much. Court will conclude this matter. You're free to go. Have a good day.
Thank you. Have a great day.
Court will note the appearance of the plaintiff in the matter. He's filed a motion for as what he entitled a non-service motion. In this matter, Mr. Clark, I note that Ms. Podolsky is not present, which is unusual because we did have her on a number of cases this morning. And you have a certificate of mailing saying you mailed the matter on the parties or their attorneys of record by first-class mail. I don't see anything else. Did you serve Ms. Podolsky in this matter?
Yes, I had to give both papers to the post office.
Well, give me that again. I didn't hear.
Yeah, I had to give both papers that I needed to serve to the post office. I had them mailed out.
Okay. We're going to contact Ms. Podolsky and see if she had received those. So why don't we do this? We'll put you back in the waiting room, then we'll have you come back in after we talk to Ms. Podolsky. And the reason I say this, at the in the motion here, you have to put the address and all of that for the party you're serving. You have Ms. Podolsky's name, but you have no address, so we don't know.
They told me I had to.
What?
Yeah, I was told that I had to redo everything. I had to rewrite the names, address, and whatnot.
Well, but what I've got, I don't have that. Did you redo the motion?
Yeah, I had to. No, not redo the motion. I had to put the addresses and whatnot on the paper. They wouldn't accept it without it.
Okay, so the motion we have, you're saying they didn't accept it, you're redoing that, is that it?
The post office didn't accept the first letters I tried to mail through, which would be
so the post office.
Yeah.
And that's what you sent on the March 6th date.
No, I never said that.
Okay, well, obviously there's some, what I'm going to do, Mr. Clark, I have some issue in whether there's proper service. So I'm going to let you renotice this matter and make sure that Ms. Podolsky is served at her office so we have proper service because she's not here. And I guess say she was here for multiple hearings today, so it's highly unusual that she wouldn't be here. So what we'll do is just renotice it for now, and then we will address it at that hearing.
What does renotice mean?
Means you have to reschedule it, just schedule it for another date.
How long that's gonna be?
It's up to you. You get to set it on a Monday, so you can set it out 2 weeks, 3 weeks, 4 weeks, whatever you want.
I gotta redo a motion?
Yes, you have to redo it, get service on Ms. Podolsky, and then we will hear the motion.
All right.
Okay, thank you, sir. Court will note this matter is before the court on the defendant's motion to modify custody, parenting time, and support. Ms. Power, I'm looking at your proof of service dated March 7, 2024, and you list Ms. Capture as the attorney for the plaintiff in this matter. Did you serve Ms. Capture in this matter?
Yes, Your Honor, I did start, but here's a proof. She refused and returned me back.
Okay, she refused because she doesn't represent the plaintiff in this action. She represents him only in the support matter. So you don't have service in this case, is that correct?
I did start the plaintiff as well, and his attorney. I did start them both at the same time, and the plaintiff, he accepted, but his attorney refused.
Okay, I didn't catch that. The reason I say it's under your proof of service, you do not, it says list names and addresses of person served. You have nothing there. So I don't, of course, just guessing as to who you served.
Oh, I don't know. I thought I approve of services. I did write the name in the person.
No, you didn't write any name under, it says on the date I sent first class mail, a copy of UPS to list names and addresses, and it's blank.
Wait a second.
The court notes that the plaintiff is not present, and the court notes the plaintiff has appeared at all prior proceedings in this matter. And because of the defects in the proof of service, the court doesn't feel comfortable in proceeding today without knowing that the plaintiff was individually served. The defendant has already stated she sent it to Ms. Capture, who is the attorney that doesn't represent him in this matter. What I'm going to do is, Ms. Parr, I'm going to adjourn this matter to allow you to properly serve the plaintiff, and then we will take it up at that time. So you can get a new date, and we'll set it for another date after you have proper service. Okay?
Yes, Your Honor, I am not sure that I'm still looking for the copy of the proof of services.
Well, all I'm telling you is your proof of service dated 3/7/24 is not proper. So you need to serve the plaintiff properly and do a proper proof of service so that we know that service was accomplished correctly. So when you do that, the court will take up your motion at that time, but I'm not going to today because there's just too many issues about whether he had proper service. Okay? Court will end this matter now at 10:35. You're free to go. Have a good day. Court will note that in the 391 PP case involving Mr. McKediak, he's filed a petition for a personal protective order. And in the other case, the 113 PP, Ms. McKediak has filed a motion to show cause for violation of the principle. Ms. McKediak, I'll let you know, your proof of service shows service on the respondent on March 14, 2024, which was last Thursday. That is improper service. So I cannot take up your motion to show cause on today's date.
Okay.
So the only issue the court will be addressing today is the petition in the 391 PP case. So Mr. McKediak, in this matter, will proceed on your petition. Do you wish to render any testimony?
I mean, No, other than what was stated in the PPO.
Well, you're gonna have to enter some testimony because I won't do it just on a written statement. Go ahead, sir, tell us what you'd like us to be aware of. What happened that you should be getting a personal protective order?
So we've been separated. She's came to my place of business, unlawfully removed vehicles.
Okay, hold on a second. When you say she,
Lindsay,
obviously she doesn't mean anything. You have to tell me who she is.
okay, I apologize. Lindsay McKediak had came to my place of business and removed vehicles. She has pending cases for that. From my understanding, Lindsay McKediak also has another PPO placed on her by somebody else, and Lindsay McKediak still has possession of her firearms and continually calls me, threatens to shoot me, threatens just continually harassing me and harassment. And then, you know, she feels she needs a PPO because she's scared of me, but she's coming to my house, driving by, calling my phone all the time by block numbers, no caller ID numbers, and threatening friends and associates. And I'd like to state or show and sending mail to my house that says happy birthday, hubby, love you, with balloons and hearts.
Okay.
With her name written on the front of it.
Okay.
And she has a PPO on me, but she continually violates it. So I feel like I need to protect myself from her feeling like I have no recourse because she can do whatever because she has a PPO on me.
Okay, you've stated that there were various dates that she called and threatened you and things of that nature. Do you have dates for that, sir?
Yeah, it was, I want to say February 9th or 11th.
Okay, what does it pertain to? Because you made a lot of allegations, so I need to know if it was, you say what date, what was the date again?
I want to say February 9th.
Okay, February 9th. What happened on February 9th?
I received a bunch of no caller ID calls, and I wouldn't answer.
Okay, how did you know it was her if you have no caller ID on that?
Because my girlfriend had answered the phone and had her on speaker, and they commenced to argue and threatening each other. And
okay, so did you hear the conversation when they were on the speakerphone?
Yes, I was in the vehicle when she answered it, and it was on my phone.
Oh, okay.
And also,
hold on. There's a lot of things we have to establish. You just can't.
Okay.
Well, did you recognize respondent's voice on the phone?
Yes.
And what did she specifically say to you? I'm not concerned about what she said about your girlfriend because she's not a party to this. So what did she say to you or make any threats to you?
The typical, if I come around, she's going to shoot me, that she's going to make sure I lose my business. She takes half of it in the divorce because I filed the divorce on her. And also numerous times of stealing my dogs and selling them, which she has in the past.
Did she threaten that or you're just bringing that up now?
No, she said that. Like, let your dogs be outside running loose and they'll come up missing again and blah, blah, blah.
Okay, so she threatened to steal your dogs.
Yes. And I have numerous text messages from her threatening to have me locked up again. I'm going to go away forever. Just repeatedly over and over. And then also, you know, I've had to have her removed from the shop by BCPD to where they told her if she come back on the property, she'd be arrested for trespassing.
So crazy.
And threatening that if I didn't pay the child support when she wanted, she'd have me locked up. There's numerous calls to Tom Mize, which was my federal supervised release officer, where she called and threatened him and his supervisors to do something about me and when I pay my child support, and trying to turn in evidence to have me incarcerated again.
Okay.
For violating no contact.
Now, on the letters that you claim were delivered to you, when were the dates of those?
This one was March 1st, 2024. And I have the picture of it. It's in her handwriting. Well, this is the actual envelope. This is the handwriting. And then this is also her handwriting and her little messages at the top, whether to cause problems between me and my now girlfriend or just antagonize and upset me.
Okay. And any other dates that you've gotten those letters?
No,
Okay.
that was the most recent.
So effectively, if I'm correct, is that you've received numerous phone calls, you've had visits at work and letters in this particular matter. Is that correct?
Yeah. Yes. Well, and also her unlawfully driving off with the vehicle that I was in possession with.
Well, that's for another matter. That's going to have to be something that's resolved through the divorce action.
Oh, yeah.
Okay.
Well, she was charged with that.
Okay. Okay. Anything else, sir?
Well, Your Honor, I wasn't in the state the date of the issue of the original PPO.
Okay, we're not addressing that today, sir.
Okay. Okay.
There's nothing in your petition. You didn't file a motion to terminate their PPO, so I can't take that up today.
Oh, okay.
Okay, Ms. McKediak, I'll have you raise your right hand and be sworn in, and we'll take testimony from you if you wish to give any.
Yes, sir.
Okay. Ma'am, I'll first advise you in this matter with what's been stated, only because there's a lot of things that have been stated. I want to make sure you understand that you have a Fifth Amendment right against self-incrimination, and you don't have to answer any questions that may incriminate you for any criminal proceedings. You understand that?
Yes, sir.
Okay. And I don't know if they'll come up. I'm just mentioning it because of what he's alleged. I don't want you to do anything that's going to have an adverse effect on you that you should not admit to.
Thank you.
Okay?
Thank you.
As to the allegations that he's made, have there been phone calls made with which you have threatened the petitioner?
No, Your Honor. No. Your Honor, I do not have time to threaten.
What he's saying is that, again, in the phone call, that he recognized your voice on 2-9, that you threatened if he comes around, you're going to shoot him. Did you say that?
No, sir.
Did you threaten to steal his dogs?
No, I do not.
Did you threaten to have him locked up?
No, sir, but there was a no contact order on his federal
Okay, that's not what I'm asking about, ma'am. Don't go off on tangents and stuff I'm not asking. You can bring that up later.
No.
Did you threaten that you were going to have him removed from various jobs?
No, Your Honor.
Did you send him a handwritten letter on March 1, 2024?
That envelope is a service of my response to the divorce, and I did not write the message on the back, but that's a service for divorce. So, in which I have the proof of service, and I have my response right here, and in which it was filed and mailed to him in the envelope. And that is what that is. That is not a letter. That is the response to his divorce.
Okay. Did you, in fact, as he stated, to go to the property where he was working and remove a vehicle that was in his possession?
No, that vehicle is my parents' truck.
Okay. Anything else, ma'am, that you would like to say in response to the
It's just, I don't threaten him, and on these dates of February 9th, February 8th, of the dog matter, of
any of his girlfriend calls me. He threatens me. This is ongoing and scary. And very scary on the part of I don't have time to threaten John. There was a no contact order with his federal.
Again, ma'am, that's not a part of today's hearing, so I don't care about what happens on his probation.
Well, what I'm saying is that there's no contact.
And I'm telling you, I don't care about what a different proceeding is. That's not involved in today's hearing.
POs, no contact orders.
Ma'am, you're not listening to me or something, because I'm saying I don't care what's happened in his other criminal action, okay? If he has a no contact order or not, it doesn't pertain to this proceeding. He is seeking to get a PPO. So anything that's happened in some other action, I don't care about.
I am saying I've taken the measures to protect myself and get PPO orders. So that way I'm not contacting him. I am not threatening him.
Okay. Anything else, ma'am?
I do not write him. I do not call him. I do not have time. I have an autistic son that I take care of, and I am constantly being threatened. I am constant, and I try to cover my butt with this. I call him in courts. So,
sir, do you have any other witnesses or evidence to present?
No, pretty much just that envelope. You know, she filled out the front. The heart on it next to her name is the exact same hearts that are on the back of the message that she said she did not put on there.
Okay.
If I also need to drop off, I can print out all the threatening text messages she has sent from her actual number that has her photo on it to the courts if you need that for more evidence. And you can look up the police proceedings from her removing that vehicle that I was in possession of. From my business.
Just to confirm, sir, was that vehicle, was it in fact her parents' vehicle?
No, they had sold it to my little brother. And then my little brother went to jail and I was using it waiting on my new vehicle.
it is still titled to my parents.
Ma'am, don't interrupt. I didn't go to you yet, so be quiet when you're not asked to talk.
There is a police report and there is a criminal case against her for removing that her dad had pressed charges on her because she didn't have authority to go and remove that vehicle. And her dad returned it back to my shop after dealing with the state police at her house. And taking it from
So
her.
the vehicle was returned?
Yes.
Okay. Anything else, sir, before we conclude?
No, sir.
Do you wish to make any closing argument?
No, sir.
Okay. Ma'am, is there anything else you would like to say before we conclude?
That vehicle is still titled in my parents' name. And this is all to get my CPL taken from me. So, and he threatens that constantly because this man has taped me up. He has came into my home. He has beat me, abused me, tried to kill me. And that's why I have PPO orders. I am so tired. I'm tired because I raised 2 children. And I am tired of these. I don't have time for these games. And he is doing this because if there is a PPO placed on me, then I cannot protect myself, and he knows that.
Okay. Well, in this matter, the court has heard the testimony. I would state in this particular case that, again, when the court does listen to testimony, the court notes that credibility is always an issue. Oftentimes, parties will allege that another party has lied or given false testimony. However, the court's found that conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, or misunderstanding, that it does inconsistencies do not always determine or denote that a party has lied. It can simply be a matter of perception. Obviously, there's some inconsistencies here. The court, in deciding whether to grant a personal protective order, I can grant a personal protective order pursuant to the sections on personal protective orders, which is MCL 600.2950. And specifically, the court can grant a action enjoining or restraining a person if there is reasonable cause to believe that the individual has committed or may commit any of the acts listed under MCL 600.2950 parens 1 parens A through K. in this particular matter. What happens is, after listening to the testimony, the court does believe that there's reasonable cause to believe that, again, that the respondent committed or may commit any of those particular acts. The petitioner stated that there was a call on February 9, 2024, in which some threats were made, that there was a letter on March 1, 2024, that had some handwritten statements on it. The court will note that also the respondent did remove a vehicle from the petitioner's possession, which was subsequently returned to the to his possession. The court will note that the respondent has stated that she did not threaten him, etc., in this matter, that in fact she didn't write on that envelope, but the court does believe that there's sufficient evidence to believe that, again, not only that she may have committed, but may commit. So the court is going to enter a personal protective order, which would prohibit the respondent from assaulting, attacking, beating, molesting, or wounding petitioner. Also, that, again, would keep her from appearing at petitioner's workplace or residence, or sending mail to him, or contacting him by phone in this particular matter, or from threatening to kill or injure him in any way. The court will not enter an order which would prohibit her from possessing a firearm, and the court will keep this in place for a period of 1 year that will allow you to get past the period of time of your divorce action. Hopefully things can settle down at that particular point. So that will be the order of the court. We'll do that, and then that's how we'll proceed.
I think
that will conclude the matter. And Mr. Kediak, you can come down to the court, and the EPO coordinator, and she'll assist you in getting a copy of that, etc. Okay?
Yes, I appreciate it. Thank you.
Thank you. You're free to go. Have a good day.
You too.
All right, let's continue.
Good morning to all of you.
Good morning, Your Honor.
Morning.
Good morning, Your Honor.
This matter is before the court on the defendant's motion to terminate the personal protective order and plaintiff's motion to show cause for violation. I do note we have in our file that there is no proof of service on the motion to terminate. Ms. Bailey Hobbs, has that been taken care of, or what?
Your Honor, we filed the motion to terminate on March 4th, and on the same day we mailed a copy by certified mail, return receipt requested pursuant to MCR 3.707 AC, which requires us to serve pursuant to 2.105A2. I have not received the signed return receipt yet. That's why the return receipt nor proof of service have been filed with the court yet.
Okay, so you don't know if service was accomplished then?
No, I do not. And if it wasn't, and the court decides that they want us to postpone this and perfect service, I would ask the court to allow us to serve either by USPS first class mail, or serving her petitioner or her counsel in her divorce proceeding pursuant to the.
Well, I'm not, okay, the attorney for the plaintiff is not involved in these proceedings, so I can't have you accomplish service upon her when she's not in this action. What I'm going to do is, because there is no proof of service and we don't even know if service was accomplished, the court is not going to proceed with that at this time. And I'll simply, because I don't want to engage in bifurcated proceedings in this matter, the court is going to put both of these matters over until we have proper service, and then we can address everything at the same time. So we're not simply having bifurcated proceedings and dredging up everything, and being redundant in the proofs in this matter. So with that, Ms. Osborne, do you understand what the court is doing?
Yes, this will be postponed to a further date
Yes.
because I'm requesting that I be represented by the prosecuting attorney.
Okay, you'll have to talk to the prosecutor for that, ma'am.
Okay, and now there's investigating, a pending investigation per State Trooper Billicky. I need to
Okay,
go
and
into.
quite frankly, at this point, ma'am, that's not an issue today. We'll have to address that at the next hearing.
Okay.
So what the court will do, because the plaintiff or petitioner does want representation by the prosecutor in this matter, court will, based upon that, obviously we can't get the prosecutor today and we don't have proper service on the other. So the court will simply at this point put the matter over. They can be renoticed once we have proper service, or it can be renoticed by the prosecutor when the prosecutor makes an appearance in this matter. So with that, is
Okay,
there
when you
anything?
say proper notice, I'm sorry, Your Honor, when you say
Yeah.
proper notice, you mean Shane being served the PPO?
No, he was, it's my understanding, he was served a proper notice of the hearing on the show cause.
Okay.
I'm just saying you have to properly serve him the next time, even though you served him this time.
Okay.
Your Honor, may I clarify something?
Yes.
It's my concern that the petitioner may not sign the return receipt as record, and that's how we have to serve it pursuant to court rule, except that the court,
Well, you can serve her personally, have a process server.
as long as that's fine with the court, that's what I'll do.
Okay. Then accomplish it through proper personal service.
Okay. Thank you, Your Honor.
Okay, thank you both, and you're free to go. Have a good day.
Thank you. You too.
Thank you, Your Honor.
Jackson, Attorney
Bye-bye.
Sachs for plaintiff.
Okay. Good afternoon, and I'll note that this matter is before the court for a scheduling conference. Mr. Jackson, you may not be aware, what happens in a scheduling conference is that we, in fact, put in place various dates and processes so that the case will proceed in an orderly fashion. I will go to the Ms. Sachs first, as she represents the plaintiff, then I will inquire of you as well to see what issues that you might have that we need to address as well. So, Ms. Sachs, what issues do you believe to be in dispute in the case?
Both legal and physical custody, Your Honor, as well as child support and property debt division as well. We are not requesting spousal support in this matter.
Okay, let me get to the file. There it is. Mr. Jackson, is that your understanding, or are there any other issues that you're aware of? Oh. Mr. Jackson?
Yes, sir.
Any issues that you believe are in dispute in the case?
No, sir.
Okay. Ms. Sachs had stated custody, support, parenting time. There's also property division issues. She said spousal support is not an issue. And so you don't believe there's any other dispute other than those?
No, sir.
Okay. Ms. Sachs, is discovery ongoing, or what's happening in regard to discovery?
Yes, Your Honor, we'd request 60 days.
60 days, okay. Yeah, the court will put I'll do May 15th as the deadline for discovery. Sir, what that means is that in this case, if you have any discovery, that means you need to acquire any information from the other side. You're going to need to get that in and done before May 15th, okay?
Okay, and when you say that, you mean like anything regarding
discovery is whereby
regarding
you,
like
that's where you request information from the other side. Okay. I guess you want to talk. Go ahead.
Yes, sir. Okay.
I'll wait until you're done.
Yeah, I would just like to say, can we get some type of custody agreement going? Because Ms. Mendelson and her attorney, I don't like the way that they're going about doing things as far as me meeting up for parenting time. Yesterday, we were supposed to have met
I don't want to know
specifics. Supposed to be no contact.
Sir. Don't just keep talking, okay? What happens if you have...
Okay, I can't really hear you too good, Your Honor.
If you have an issue with custody, parenting time, any of those, you can file a motion, have that heard on any Monday, and then the court will address whatever you need to have addressed at that time.
Yes, sir.
Okay, the
No.
court has set June, the month of June, as a mediation month. Ms. Sachs, who would you like as the mediator?
Attorney Brundage, Your Honor.
Okay.
No preference on a secondary.
Okay. Mr. Jackson, do you have any problem with Mr. Brundage serving as the mediator?
I don't know. I feel like I should.
Well, I know no doesn't help me much, okay?
Your Honor, I believe he's frozen.
Oh,
I lost reception.
okay. I'd ask you at that point if you had any dispute with Mr. Brundage serving as the mediator.
Oh, I don't really know any particulars about him. So that's why I was saying I would like to request legal counsel.
Well, we don't appoint an attorney to represent you in domestic relations matters. So the court.
Yes, sir. That's why I was saying, could I have it adjourned until I can get one?
Well,
so that I can get one.
What I'm gonna do is, in this particular matter, I will let you know that Mr. Brundage does about 85 to 90% of all the mediations in Calhoun County. So I'm gonna leave him on there. If you get representation and you decide that you want another different mediator, you can file a motion and request that, okay?
Yes, sir. Yes, sir, Your Honor.
Court will set July 8, 2024 at 1:30 p.m. as a settlement conference. Parties are required to be present unless we have full resolution prior to that time. With that.
Can I get a date again?
You're going to get all this in writing, sir. So you're going to get, it's going to be on the order.
Yes, sir.
Okay. So the court that will conclude what we need to do today. Sir, when you talk to your attorney, talk to him, because there are dates and things in the case scheduling order that you have to comply with. And if you don't, it could have a consequence to your case. Okay.
Yes, sir.
Okay. That will conclude this hearing, and you're free to go. Have a good day.
For plaintiff and
All right, thank you.
for defendant. All right, thank you.
Okay. Good afternoon.
Good afternoon.
This matter is set before the court for a status conference. I note, and I've been informed that this case is very, very old. Back in December, we were informed that you had resolution of all the issues. Why now, 2+ months later, do we not have resolution?
Your Honor, we did submit a proposed judgment and UCSO to friend of the court for approval. FOC did object, in part because a GIF and a 4D form weren't filed with it. That was an inadvertent error. We did send that in. The other reason it was objected to was the proposed judgment was silent as to physical custody. That's an easy fix. I spoke with opposing counsel about it. I believe she just made it today during our phone call. Is that correct?
Correct.
With regard to the proposed child support order that I submitted, part of our agreement was that my client's earnings that she made as a result of selling things on eBay, which she does mostly as a hobby for the past few years, would be included in the income calculations. I sent over to opposing counsel spreadsheets showing my client's earnings for the past 3 years from eBay, and submitted a UCSO based on the information I had gleaned from those spreadsheets. Opposing counsel did not agree with those, with my numbers. I had an opportunity to speak to her late last week. She indicated that it looked like there was a mathematical error in my calculations based on those spreadsheets. I reviewed them again, and it did not appear that there was an error, and reviewed them, and my client also reviewed them. It did not appear there was an error. However, in reviewing those spreadsheets again this morning, apologies, Your Honor, I think I X'd out of my video by mistake.
That's fine.
In reviewing those spreadsheets again this morning, it appears that there may have been a miscalculation. I'll need to dive deeper into those and make sure that that is indeed the case. I spoke with opposing counsel. I should have that. I should be able to have that completed by tomorrow, and an updated UCSO submitted to FOC for friend of the court.
Okay, thank you. Ms. Thomas, is that the only issue that we have? Is it related to the income?
Yes, and then I had used, this is the case that I had actually read the verbiage to you, and
right. Okay, that's fine.
and we fixed that too. So yeah, those two things. That's it.
Okay. Well, get that done, Mr. Umloff. Let us know. Call our office. Let us know when that has been submitted. Unfortunately, the FOC is running about 3 to 4 weeks behind on approval. So we take proofs in this.
Yes, we did.
Okay.
Yes.
So get that done, let us know, and then we will, we'll see if we can't contact the front of the court and get this moved through quicker because the time frame is really delinquent.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. You guys, you're free to go. Have a good afternoon.
Thanks.
Same to you, Your Honor.